Good afternoon, everyone. It's Tuesday, February 11th, 2025, and it is about 7 minutes after 3 o'clock. We do have a quorum that has checked in, even though it doesn't look like it. This is the meeting of the Senate Elections Committee. We have 3 items on the agenda today, and we're going to try to be as prompt as possible. So we're asking all of the testifiers to be as brief as they can to get their message across. And we may have a timer here that you won't see, but we'll still try to keep people prompt and have them wrap up as timely as they can. If we don't finish the agenda by 5 o'clock, we'll have to meet on Friday and take up the rest of it then. So since Senator Putnam is with us now, we'll start with his bill. Senator Putnam. And testifier, please take the stage. Senate File 863 is Senator Putnam. And we have an author's amendment, an A2 author's amendment. I'm assuming everyone has that in their package. And that is an author's amendment. So all in favor of the...
Senator
I'm sorry. Oh, we need a... Okay, Senator Westland, who is a member of the committee, moves the A2 amendment, author's amendment, to get the bill in the form that Senator Putnam desires. All in favor, say aye. Aye. All opposed, nay. So we have one nay, but the motion is passed and the amendment, A2 author's amendment, is added. Senator Putnam, please proceed with your testimony.
Thank you very much, Mr. Chair and members, except for Senator Limmer. I'm glad to have an opportunity to talk about this issue with you today. Months ago, my friend Steve here called me to tell me a story, and it troubled me deeply, and I expect that it'll trouble all of you as well. I met Steve a couple years ago, and I knocked his door, and we kept in touch. And I knew he cared deeply about democracy and that he'd actually fought for it in uniform, and that matters to me. So it didn't surprise me at all when he ran for mayor of St. Cloud in 2020. He did pretty well in that race, made it through the primary, but ultimately didn't get the gig. So I also wasn't surprised when he decided to run again in 2024. But I guess somehow his employer was, because he was fired for running for office. I'm going to say that again. He was fired for running for office, explicitly. His employer told him he was being fired for running for office. When Steve told me that, I was shocked. I thought there is absolutely no way that could possibly be legal. And yet, there's some ambiguity in the law. And this is our opportunity to fix that problem. Senate File 863 is not a simple bill, but it does solve a simple problem. In a country that aspires to democracy, everyone should be able to run for office without fearing retribution or the end of their livelihood. This bill expands existing statute which prohibits economic reprisal, termination of employment, and physical coercion for political activity to also specifically include protections for candidates running for office. And after this amendment that we just accepted, it also allows for some penalties to teach a lesson to those companies that would do this. Now, members, we didn't get a chance to talk through the amendment, but the one distinction between this amendment and the prior bill is this question of penalty. Because we know that there are large corporations out there that will sneeze at a $3,000 fine, that will have no consequences for them at all whatsoever. So we wanted to make sure that there was still an opportunity for redress. That is the bill itself, Mr. Chair and members. It's pretty straightforward. It's a simple problem, but it's a big problem for America and for our democracy. And I think the best person to tell the story of why this is important is my friend Steve. So, Mr. Chair, with your permission, I have a testifier.
Thank you, Senator. Mr. Schiller, please start with your identification for the record and then proceed with your testimony.
My name is Stephen Dwayne Schiller, and I would like to thank Senator Putnam for inviting me to speak with you today, and for you, Chairman, and the committee for hearing my story. Because again, as Senator Putnam said, it's a really interesting story and a very disturbing story as well. You know, I'm a retired First of all, I'm a retired combat disabled veteran of 22 years. My last deployment was Iraq in 2003, where I ran a base camp along the Iraqi-Kuwaiti border. Duty, honor, and country is the foundation of my life. It's been that way my whole life. When I originally enlisted at 19, and at 20, I decided to join ROTC because I felt that if I wanted to be able to make changes in the training to be better equipped, then I needed to be able to be in a position to do that. So in 2022, 2000 and 2 years, that would be 1984. 1984, I actually joined ROTC at St. Cloud State University. And 2 years later, I was commissioned as an officer. I was a logistics officer for 22 years. In February of 2024, I was offered a job as the commercial salesperson for Culligan Packard of Minnetonka to be working in the St. Cloud area. On July 22nd, I was asked to be in a meeting with the sales manager, Andrew. He was the territory sales manager. We met in the St. Cloud office. And at that time, he had informed me that they were aware that I was running for mayor of St. Cloud, and that HR was aware based on a video that was, because I had been interviewed by the former mayor, Mayor Kleiss, and they were aware of that interview. And they said that at that time that they were going to have to go back to HR and review what their position was going to be. The next day, I was sent an email stating that they wanted to have a meeting. He wanted to have a meeting with me at 4 o'clock the next day, which would have been the 23rd of July. And he set the meeting for 4 o'clock in the afternoon, which was right after the office closes. So as I saw a smile, as you know well, when you get set for a meeting at 4 o'clock, when everybody's gone, you know what's happening. You know what's gonna happen at that time. So I continued to work. I had contracts that were pending, and I continued to work, continued to submit contracts from companies that were willing, that wanted our service. And because the fact is that whether I knew I was going to get terminated or not, it was my job to keep working, to fulfill those obligations that I was hired for. So I showed up at 4 o'clock in the afternoon on Wednesday, and my wife was with me at the time. I had asked her to attend the meeting with me. He refused and said that she was not allowed to come into the meeting. So, and I said, well, if this is going to affect me and my employment, that I think that she should be allowed to be in. He said, if you want her to be in here, we can no longer meet. So I agreed to meet with him. At that time, I knew what was going to transpire. I did record the meeting. And he, at that time, said that you are now terminated, and asked for all of my, my computer, asked for my keys, asked for my phone, and said that I was going to be terminated. And I said, so what about me getting paid for some of the work that I had already done? And he said, well, he was going to have to consult with HR. At 5:45 that night, I got a call from HR. And HR said, oh, and by the way, any contracts that are not in from the employer, from the customer by midnight tonight, we are not going to pay you on. And I was like, so I've done all this work, I've got thousands of dollars that are sitting out there, and you're telling me that if they don't get it in by midnight tonight, that I'm not going to get paid? And she said, yep, you're right. And I, at that time, you can imagine how I felt. I was just, you're numb, because you're like, what just happened? Where is this going? And so at that time, there was nothing more I could do. So that's when I reached out, and I think I took a few days, and I reached out to Senator Putnam and kind of explained to him, what was happening. And at that time, then I had filed for unemployment. And there's a stipulation that states if you are terminated, you cannot collect unemployment. Again, I was like devastated, thinking, okay, this company just let me go because I was running for mayor. Oh, and I left out the part that I said to him, if you wait 21 days, the primary is happening. I have not been campaigning. I will not make it even out of the primary. And they said, sorry, but we're not going to wait 21 days. You're done. 21 days went by, the primary went by, and I finished 6 out of 6. In fact, I had gotten an embarrassing 200 and some votes. So had they have waited, this wouldn't even been an issue because I would have never been moving on. They never gave me the opportunity to, they never gave me any opportunity to keep my job, which again was very devastating. So then, so I, at that point in time, I had appealed my termination or my unemployment. At that time, we had a hearing by phone with the unemployment judge. And what the unemployment judge said to us is that basically he said, first of all, there was nothing in my testimony on this topic that suggested that I was any inaccuracy or deception, that my testimony was credible to the point. And the unemployment judge also said that, Culligan discharged me because I entered the mayor's race without telling them. And what they deemed is that I was being dishonest. But he also said that I was within my legal right to run for the office, and that nothing required me to tell Culligan that I was doing so. That nothing that I did amounted to employment misconduct. And so I was awarded, unemployment. But then there's a waiting period because they can contest it. Luckily, they did not contest it, and I collected my unemployment. But during that process, I started looking for jobs. And I was, as a logistics officer with my training, my government training, I was very qualified there was 3 logistics jobs at Centricare, which Centricare, one of their big suppliers is Culligan. I made it up until the last 3. 2 of us were going on for an in-person interview, and all of a sudden they ghosted me. Just disappeared. Didn't even get an acknowledgement saying that they were moving on without me. They just ghosted me. They've ghosted me 3 times, and so I know it's just not a coincidence that I'm being ghosted. I have had numerous employment applications that I've put in, but you can imagine when you have to fill out an unemployment application and it says, have you been terminated? Again, duty and honor and country. So I have to answer yes. When you're terminated, when you're listed as terminated, nobody wants you. So I've been unemployed since July 24th of last year. My unemployment ran out in December. The only thing that I have right now is the fact that the government, I was now eligible for my pension. So I get my pension and my insurance from the government. Now, what I'm really asking is I'm asking for the government to stand behind me and to protect me and any others that this could happen to, because this is a real, I guess what really triggered it is when the news story came out about one of your colleagues that had trouble with an employer and had to hire an attorney. And that really hit home to me at that point in time, saying, this is a real problem. This is not a problem that's just for me wanting to run for office, but this is a problem for you as well. And if we do not hold employers accountable for their illegal actions, then where are we? What do we have as people? It's just so it's been. And I came back from the war with PTSD, and it has really hurt me from the standpoint of going a little backwards because of the fact that I've had a hard, depression, feeling self-worth has been part of my life for a long, long time. And I was actually better. And this just created a huge setback for me as a person. And so therefore I ask for your compassion and help.
Thank you, Mr. Schiller. Thank you for your testimony. Any other comments you have, Senator Putnam?
Thank you, Mr. Chair. I just want to say that as tragic and profound as Steve's experience is, and I'm very grateful for him to be here to tell his story, what we're talking about is a precedent. We don't want this to happen to anybody else. Every American should have the right to run for office without fear of being fired for having done so. And the fact that this was done so brazenly, so explicitly. A part of the story that Steve didn't tell is that when he was fired, his boss said, the only one in this company who can run for office is me and my son. Out loud, openly. And they did that because they have no fear of consequence. Members, Mr. Chair, this is our opportunity to make that consequence clear and to protect people in the future who want to serve their country, as Steve did in Iraq and as people do when they run for office.
Mr. Chair, could I make one comment that I forgot to make?
Mr. Schiller,
Thank you.
briefly, please.
The day after, they actually held a meeting in the St. Cloud office with the general manager, the sales manager, and the district manager. And at that time, they addressed this, and they, in front of the rest of the staff, said this exact same thing, that no one in this company is allowed to run for any political office, whether it be school board, city council, mayor, state representative. No one was allowed to run except for the owner and his son. And when one of the employees kind of brought up a point, he said, so in other words, I can't, if I want to run for school board because I want to change the way that things are going for my own kid. And they said, you have to choose between your job and running for school board. And in that regards, no one can do that because that's your livelihood. And he actually, when he found out that I was coming today, he wanted to come and testify. Even though he's still working there, he wanted to come and testify to tell his story. But unfortunately, he had to work today and he wasn't able to.
Thank you, Mr. Schiller. Do we have member questions? Senator Cran. Senator Limmer first, I guess, yeah. Senator Limmer.
Thank you, Mr. Chairman. Mr. Schiller, I was wondering if I could ask you a question. I'm looking at the existing language in statute, and it involves reprisals prohibited and a penalty that's recognized. Why wouldn't the existing language in law cover this exact situation? And if so, did you pursue any legal defense or a legal action against your former employer for doing that?
Mr. Chair, if I may take the first half of that question, if that's okay.
Senator Putnam. Yeah.
I think that in our conversations before as we were drafting this, the assumption was that political activity is too general, is too vague, and doesn't explicitly name running for office. The initial statute had to do more with kind of protecting a certain sense of political activity, like volunteering, doing those kinds of things, or being hired for a job that is explicitly partisan in nature. So really that part of the statute change is really just to say, you know what, running for office is political activity. That's the first part of it. Now in terms of Mr. Schiller's other stuff, I'll defer to him on that, if that's okay, Senator Limmer.
Mr. Schiller.
Thank you, Chairman. Could you state the last part of that for me, please, Senator?
Yeah, thank you, Mr. Chairman. Mr. Schiller, did you pursue any legal action against your employer when your employer did that to you?
I did hire an attorney, and in fact, he was suggested because of the fact that employment law was his specialty. And when I originally hired him for the unemployment, which he was then able to help me secure my unemployment. Then again, when I approached him about being able to sue, he said, based on this current statute, there really wasn't any opportunity for you to sue civilly. And even if you wanted to, the chances were slim to none, and it would be very costly. So what we have done to this point in time is he is going to do a follow-up letter to Culligan's attorney to see if they're even willing to talk about it. Because to this point in time, they have ghosted us.
Mr. Chair.
Senator Limmer.
There is not a specific cause of action listed under this statute. However, there is a criminal violation on lines 1.15 through 16, gross misdemeanor. Did you ever bring this to a county attorney to pursue a criminal action against your employer?
Mr. Schiller.
Thank you, Mr. Chair. Thank you, Senator. No one is willing to invest the time for a misdemeanor of this caliber. So from that standpoint, would I love to see a misdemeanor assessed? Absolutely. But finding someone that is willing to invest the time with what they would consider to be such a minor issue is difficult.
Mr. Chairman,
Senator Limmer.
I know there's a few county attorneys that are taking it upon themselves to decide whether to charge criminal charges against those who violate the rights of others. I'm kind of surprised that I would have, the reading of the original language, I would have thought would have been a cause enough for action. Sorry that you had to go through that type of experience. We certainly would want to encourage people without reprisal to run for office. When I first read this, I thought that this was already covered in law. Maybe the clarification of the word employer being added might be something, but certainly individual or association, I would assume would be enough to make the action. But if you don't have a county attorney that wants to bring this charge forward, then maybe that should be an issue that you raise in your next election, Mr. Schiller.
Thank you,
Mr.
Senator.
Schiller. Senator Cran.
Thank you, Mr. Chair. And Senator Putnam, and to our testifier, so were there any written policies as it relates to political office prior to your pursuit?
Mr. Schiller.
Thank you, Mr. Chair, and thank you, Senator. It's actually there, and we had left those with the gentleman. It states right in there in my unemployment that in the hearing they signified that there was no written or verbal policy that was ever expressed to any employee. So this was just something they just decided to come up with.
Mr. Chair, Senator Curran,
Senator
the document to which Mr. Schiller is referring is, he brought copies of the judgment given by the unemployment judge. So those are back there with Mr. Freeman, and he can pass them out for you if you guys would like to see that detailed
Mr. Chair.
thing.
Senator Cran.
Thank you, Mr. Chair. And Senator Putnam, the reason I ask is many employers have those terms and conditions. So does this prohibit them from having those terms and conditions in their employment agreement?
Senator Putnam.
Mr. Chair, Senator Cran, my understanding is that it would make them unenforceable, which I think is a good thing in general. But note that the larger statute makes it very clear that there are organizations that are partisan in nature. So we're not saying that, say, the DFL couldn't ask someone if they're Democrats before they hired them. That's already in the statute, is exempted. This is exclusively for just general private employment. So if any business said, look, here on this paragraph says if you take this job, you can never run for office, that I think would be explicitly denied by the statute the existing statute that we are clarifying.
Mr. Chair,
Senator
Senator Putnam, but that's a free and open contract that somebody knowingly, willingly engages in. And so you're saying that's an unacceptable condition of employment. But what if it has direct conflict in your ability to perform that job, which I don't see that addressed in either of the statute, you're right, or in the foundational one, and or certainly, especially bringing right of civil action, which could certainly be weaponized against employers too. So you're saying that you believe this should supersede employment contract law if an individual willingly accepts the condition. In this scenario, that right, I believe you. I don't
Right.
that there was none, written or otherwise, but there are many places that it does have a direct conflict of interest in your ability to perform your job and serve an elected. But we have an Office of the Legislative Auditor who has that as a term and condition of the employment contract. Would this supersede their ability to run for office? Or would it nullify their existing employment contract and requirements for that agency to function or to prohibit them from running for office?
Mr. Chair, Senator Cran, I think that's a legitimate concern, but I don't
Senator.
think that is actually the issue here. I think that the deeper statute, my understanding of the deeper statute in this larger context, is it does explicitly accommodate for those moments when a business or an organization would be, by its nature, political and would require some sort of political identification before that hiring. My understanding is that is already in other statute around this space, so that it actually wouldn't be as necessary.
Mr. Chair?
Senator Grant.
But you didn't make the delineation before, and I don't see any delineation there, because one, OLA is one. Financial institutions are others. I happen to work for one that was a precursor, that they didn't exclude your ability, but you were very well informed. It must be an approved activity. And in this case, you're describing it as, well, we just decided it can't even be an approved activity that this would supersede their ability under that agreement, under your employment contract. And then we have nonprofits who are funded by state government. Would that supersede their ability to protect themselves from conflict of interest by having an elected official who would vote on their funding?
Senator Putnam.
Senator Carlson, Mr. Chair, and Senator Cran, my understanding is that that's not the case. The conflict of interest are obviously separate from the actual hiring and running for office. So I don't see the contradiction that you do. I understand the concern that you're raising, but I don't see the contradiction that you do.
Mr. Chair, Senator Putnam, I think we'll have to continue to do a little work on it, but I get it, right? All of us, most of the people I serve with have had that same financial harm, right? Being unemployable. In a financial institution, you're a political liability. And so, and there's some legitimacy to it. But they have those in their policies today. And I'm not comfortable with the answer, the description that your initial said it would supersede an employment contract even if you engaged in it voluntarily. And I think there have to be a significantly more work done to definitions about who and when it does cover, and to subvert just basic employment contracts. But one being a person that's been harmed by it and served. And so opening up for civil cause, and I can see from a partisan perspective these things occurring just for political purposes, to harm somebody who didn't share their political view. I mean, it's to open. We've seen so much expansion to bring civil cause or civil action over the last 2 years. It's an attorney's dream. No offense to all the attorneys here, but it just seems like it goes a wee bit too far. And I don't discount the harm. I get it, but I just think that need more clarity, because if you're going to nullify it in an employment contract, I just think that that's outside of our bounds. So thank you, Mr. Chair.
Mr. Chair, if I may, Senator Cran, I appreciate your concern, and I'm willing to do a little bit more tinkering, again, in the context of the larger statute and the deeper law. So, yeah, thank you for the concern.
Thank
I
you,
think it's
Senator.
valid.
Thank you, Senator Putnam. We've got some other questions here from Senator Westland, Vice Chair.
Yeah, just for clarification, the definition of employer that's used in this statute states employer includes all persons employing others and all persons acting in the interest of an employer, but does not include the state or any political or governmental subdivision thereof, nor any person subject to the Federal Railway Labor Act as amended from time to time, nor the state or any political or governmental subdivision thereof, except when used in section 179.13. So they are specifically excluded from the definition of employer. My understanding is this is going to judiciary next. I just want to say, Mr. Schiller, I think it's appalling that this happened to you. I think what is, you know, we are a citizen legislature. We have a citizen Congress. We are average, everyday, normal people who do all kinds of work and all kinds of jobs. And for someone to literally lose their job or their livelihood because they are exercising their right to participate in our political process is appalling, and it is chilling. And so, Senator Putnam, I appreciate you bringing this forward. I appreciate the amendment that you've brought forward. And I fully support this bill and look forward to hearing it in judiciary.
Senator Matthews.
Thank you, Mr. Chair. Senator Putnam, and to the testifier, I came in partway through, so apologies if I missed this. Is your intent with this bill stating that as long as you're meeting your required work hours, anything additional is basically your own time and you're free to do what you want on your own time? Or is this bill trying to exercise the right of telling your employer, I now need to do less time here at my job to accommodate this campaign I want to do, and I need to reserve the right to keep my job here? Could you clarify that for me?
Thank you, Mr. Chair and Senator Matthews.
Senator Putnam.
Yeah, this is, as the documents that Mr. Freeman has that could pass out, is the actual judgment from the unemployment judge, said that Mr. Schiller did absolutely nothing wrong. This had nothing to do with how he was performing his job, and was explicitly because he was running for mayor. There was no ambiguity in it all whatsoever. And Mr. Schiller can tell the story again, but that's the part that frustrated me so much, is there wasn't even care enough to be shady about it. They just said straight up, you're fired because you're running for office. So that's what we're trying to get at.
Mr. Chair
Senator
and
Matthews,
Senator
follow.
Putnam, thank you. I do think that some of the language needs to be looked at. I share Senator Cran's concerns that it just says an employer must not engage in threatening loss of employment for an individual, including when that individual becomes a candidate for elected office. So I think you do need, I think there's some situations you're trying to catch in and some you're trying to avoid, and I don't think that's reflected in the language. The second thing I want to point out is on your amendment, line 1.18, why is the language directing the Campaign Finance Board to fine private employers, private businesses? I would argue that's not the Campaign Finance Board's purpose. Maybe bring it to court, if anything, but why would campaign finance have jurisdiction over McDonald's or the manufacturing business in your district or the ma and pa shop or something like that? My understanding is the board, it would be in this chapter of campaign finance, so please confirm if that's what's the intent here or what the action is meaning with this civil penalty.
Mr. Chair, Senator Matthews,
Senator
thank you
Putnam.
for the question. I don't see reference to the Campaign Finance Board in here, so I might be missing something.
Mr. Chair,
Senator Matthews.
make sure I'm on the right bill.
Yeah,
Yep,
be sure Senator Matthews, be sure you're looking at the A2 amendment.
I am. Line 1.8 of the line 1.18 of the A2 amendment, maybe I misspoke before. An employer who violates this section is subject to a civil penalty imposed by the board of up to $3,000.
I see that now.
Who's that board? Is that Campaign Finance Board?
Senator Matthews, we have Mr. Sigurdson from the Campaign Finance Board coming to help us understand that.
Mr. Chair, committee members, Jeff Sigurdson, Executive Director of the Campaign Finance Board. Section 10A36 is already part of course, Chapter 10A, all of which is under the jurisdiction of the Campaign Finance Board. So this provision, $3,000, I believe, was added as a suggestion, frankly, for me, because the current statute says that you bring the complaint to the board, but then the board can't do anything about it. Even though if the board was to find a violation, it would not have the ability to apply any penalty. All it could do would basically be issue findings saying, well, there probably is a violation. So this is adding some penalty for the board to be able to apply.
And Mr. Sigurdson, the board otherwise has authority because this is found in the Section 10A. Is that correct?
Mr. Chair, that's correct. This is already language in 10A that's obviously been modified.
Okay, thank you. Senator
Mr.
Matthews,
Chair.
follow-up.
Thank you. So I get that maybe you can get reports from candidates. I would strongly argue that campaign finance should not be in the business of going around fining private businesses. Your jurisdiction is to individuals that open up campaign accounts for the purpose of running for office in Minnesota and ensuring that those campaigns act in accordance with state law and have fines for violations of those persons. But I would strongly argue that that should not be extended to giving campaign finance monetary penalty authority over every business in the state of Minnesota. I think we should put in here that you could seek a civil penalty at a court up to $3,000, put it in law, argue it that way. And that way you have your due process and you get representation or whatever is needed, or small claims or whatever is needed going through that process. What's a local employer at a ma and pa shop in a small town gonna do when a letter shows up, campaign finance is fining you $3,000? I don't think that that jurisdiction ought to extend there. So I'd maybe ask council to help me figure out what an oral amendment might be to pull that out of there and correct that part of the bill.
Senate Council will help us understand that.
Senator Matthews, are you proposing just to eliminate the civil penalty imposed by the board at this point, and then when it gets to judiciary, work on maybe alternative language?
I'd be fine with
Senator
that.
Matthews.
Mr. Chair, and Ms. Stengel, thank you. I would be fine with that. I think we should not let this leave this committee with this proposed type of authority for campaign finance.
Then, Mr. Chair and Senator Matthews.
Council, Senate Council.
I think what you would want to do potentially then is on page 1, line 17, reinstate guilty of, delete subject, and on page 1, line 18, delete all of the new language. And that would have the effect of just leaving the current law of stating that person who violates this section is guilty of a gross misdemeanor.
Senator Matthews, is that what you're thinking? Does that match what you're thinking?
I'm okay with that. As a start, I think there's probably a civil action piece that needs to be added into it, and that needs to be pursued with the court, and maybe judiciary is the best one to figure that part out. But I do agree with we should pull this line out of this bill.
Council Stengel.
Thank you, Mr. Chair and Senator Matthews. If you look up just a little bit on lines 13 through 16, there is a civil cause of action that's in the A2 amendment. So that's that's in place to work with once you get to judiciary.
Okay, I appreciate that. So
Senator
I would make,
Matthews.
Mr. Chair, I would make the oral motion as read by council.
Senator Putnam, reaction?
As I understand it, it seems reasonable to me. I was just conferring with Mr. Sigurdsson about the board's capacity and ability to fine being as tremendously categorically limited as it now is now. And I agree with Senator Matthews that it would seem curious to do this on just this one issue and not on others. So for that purpose, to the extent that I understand the amendment, I think it sounds all right.
Just as a curiosity, Mr. Sigurdsson, is there any other part of this statute area that allows the board to fine a private employer or a private person that is not involved in candidates?
Mr. Chair, if I understand your question, yes, there is provisions for fining organizations which are not registered, which are called unregistered associations. For example, if a business made a contribution, which are prohibited, to candidates, the board could fine the business or the unregistered association if it wasn't incorporated as a business. That's a simple answer. Frankly, there's a lot of if, ands, or buts there, but nonetheless, there is the authority to fine entities that are not registered with the board, and that's always existed.
Okay. Thank you. And I think our council perhaps can read the oral amendment, and we can take a vote on it.
Thank you, Mr. Chair. On page 1, line 17, reinstate guilty of and delete subject. On page 1, line 18, delete all of the new language.
Including the violation.
Yep. So then it was this section, guilty of a gross misdemeanor.
Okay. So just for clarity, we reinstate guilty of and also delete a violation of this section. So it just is guilty of a gross misdemeanor. All those understand it? Any further questions on the amendment? All in favor, say aye. Aye. All opposed, nay?
No.
The motion does not prevail.
I call division, Mr. Chair.
Senator Matthews calls division. Just ask for hands. Division is called. All those in favor, raise your hand. All opposed, raise your hand. The motion does prevail. Okay. Any other questions for the presenter?
Senator Port.
Senator Port.
Thank you, Mr. Chair. Thank you, Senator Putnam, for bringing this bill. Mr. Schiller, I'm, share with everyone else my distress that this happened to you. Senator Putnam, I think you're hitting the nail on the head when you're talking about we want people to be able to serve their communities in whatever way they're able, including running for office. And that, to me, is already in the law, as we talked about this the other day when we brought it up. I appreciate the clarifying language to add running for office to make sure that that is understood to be political activity. I don't think that this is not new law, right? Like, this already existed. You're just clarifying it. And when people make private contracts, they still have to follow the law. So I appreciate you bringing this forward. I look forward to continued discussion as this moves through the process. And Mr. Chair, I would move that we move this bill to be recommended to pass and move to judiciary.
Thank you, Senator Port. Senator Port moves to moves that Senate File 863 be recommended to pass and sent to judiciary, 863 as amended. Be recommended to pass and sent to judiciary. All those in favor say aye. Aye.
Aye.
Opposed? Nay. The motion prevails. It's sent on to judiciary. Thank you, Senator Putnam.
Thank you much, Mr. Chair and members.
Thank you, Chair and Senators.
Thank you. Our next bill is from Senator Boldon. And as a reminder, if we don't finish these bills today, we'll be coming back on Friday. We're a little behind already, but we did say the first two bills were going to be done in an hour. And Senator Boldon has an author's amendment, and we should work on that. It has been sent to all members. And it is so small that, and the bill is small, so that we did not feel it was worth doing an amendment that would be in anything in depth, so we did a delete all. No, I'm sorry, that wasn't yours, that was Putnam's. Okay, so we did do the amendment, and it is an author's amendment for Senator Boldon, and Senator Boldon moves the A2 author's amendment to get the bill into the form that she would like to discuss it. All in favor say aye.
Aye.
All opposed, nay. The author's amendment is adopted. Senator Boldon.
Thank you, Mr. Chair and members. Perhaps I'll get us back on track with time because this is a relatively simple bill. It essentially would create a short-term working group with the goal of looking at the reporting for local candidates. Currently, local candidates, so folks who are running locally for school board, city councils, the reporting location where those candidates submit their campaign finance reports varies from locale to locale, and it often is done by city clerks who have a number of other things in their job description, and this is just one thing that they do. And so the working group would look at the feasibility, the pros and cons of the current structure for that versus having that reporting be directed to the Campaign Finance Board. This would do potentially a couple of things, and that's what this working group would look into. One, it might, shifting it to that central location of the Campaign Finance Board, it would take that work off of the local city clerks and allow them to do the many other things that they're responsible for. It would allow for more transparency. It would be a one-stop shop for the public to be able to go to the Campaign Finance Board and see all of this information. And two, it would be a resource for both candidates and treasurers, who are often volunteers, to have that information to be able to go to the CFB for that central information versus going to a city clerk who, again, is, those are wonderful folks, but they're doing many things as part of their job. I would direct your attention to, there is a letter in your packets from an individual in my district who just recently ran for and was elected to city council, and he speaks both as a candidate and as a member of the public on the potential benefits of looking into this. There also is a letter who speaks to really the intention of the amendment that we just adopted in adding another individual from the to be able to speak to the small cities. And so you'll see the proposed members of the committee would be from the League of Minnesota Cities, the Association of Minnesota Counties, Minnesota Association of Townships, School Board Association, as well as legislator representatives, really to get a that perspective, the multiple perspectives, to really look at this issue. And the working group then would report back to the legislature and make recommendations so we could have more information on which to make a decision on really what is the right thing to do in this space. And with that, Mr. Chair, I look forward to the discussion.
Thank you, Senator Boldon. Any questions from the committee? We have Senator Barr.
Thank you, Mr. Chair. Senator Boldon, just a recommendation here. I'd like to offer an oral amendment with your, with your consent here. But on your A2 amendment, you just said small cities. Could we change that in the adopted or offer an oral amendment to cities of the fourth class, so it would be 5,000 or smaller? So we just define what a small city is. Or would you prefer third and fourth class so that we actually don't have cities like Bloomington, which are not cities of the first class, and then you'd actually have define what you really want here?
Senator Boldon, have you seen this amendment?
Thank you, Mr. Chair. No, we haven't spoken about this, but I appreciate the intent and really defining what do we mean by a small city, because it really is the goal that we get the voice of small cities. I will admit I don't have the definitions in my head of the classes of the city, so third class, fourth class. So perhaps council could remind me of those, and I am open to the idea.
Council Tango.
Mr. Chair, and perhaps if that is not at the fingertips of council, I understand that, and I am willing to work with Senator Barr to come to language to do what he is intending, which I think makes good sense.
Senator Barr, could you repeat your thought on an amendment?
So, yes, Mr. Chair. So I was thinking instead of the word small city, we just phrase that as city of whichever class Senator Boldon would want. My suggestion would be cities of the fourth class. So that would be the smallest cities. I believe that's 5,000 and smaller, I believe.
Okay.
If Ms. Stengel has an answer for
Council
us.
Stengel is going to help us understand.
Thank you, Mr. Chair, Senator Barr, Senator Boldon. A city of the fourth class is 10,000, not more than 10,000. Third class is 10,000 to 20,000. Second class is 20,000 to 100,000. And first class is 100,000 or more. So again, focusing on third and fourth class is 10,000 and below. Third class is 10,000 to 20,000.
Thank you. Senator Barr, what's your preference on that?
Through hand signals here, Senator Boldon and I have communicated that we would, I believe she'll accept a oral amendment to change, strike small cities and make that cities of the fourth class.
Thank you. Senator Boldon?
Thank you, Mr. Chair. Thank you, Senator Barr. I think that is a reasonable alteration and would support that oral amendment.
Thank you. Council will read the oral amendment for us.
Mr. Chair, it's amending the A2 amendment on page 1, line 3. Delete small city and insert city of the fourth class. So would say one of whom must be from a city of the fourth class.
Any questions? Senator Limmer.
Thank you, Mr. Chair. Having heard the amendment, Senator Boldon, is it your intention to exclude representatives from the third and second class cities?
Senator Boldon.
Thank you, Mr. Chair. Senator Limmer, no. The intention of the amendment was specific to, and this was in collaboration. I think there also is a letter in your packet from Minnesota Small Cities, who had requested specifically to have the voice of small cities, because processes, systems, resources are different for a city, a very small city versus others. So, nope, not my intention to exclude. One would be from a city of the fourth class, and one would be, could be from any others.
Follow-up, Senator Limmer? No follow-up. Senator Luciero?
Thank you, Mr. Chair, but I just wanted a point of clarification then to Senator Limmer's point of asking second and third class. I just want to confirm, it is our intention then to exclude the first class, right? We're all in agreement in that.
Senator Boldon?
Thank you, Mr. Chair. The intention of this amendment and the representation here was to include those from a small city. I mean, that's the intention, to have that voice. So I'm looking at one member will be appointed by the League of Minnesota Cities. Now we're at 2 members. Nothing excludes cities of the first class.
Senator Lucero?
That's it. Thank you.
Thank you. Okay. We have the amendment as read by Senate Council. It's to include all fourth class cities. And all those in favor say aye.
Aye.
Opposed, say nay. The motion is adopted. Senator Boldon, any further comments? We have a question from Senator Matthews.
Thank you, Mr. Chair. And Senator Boldon, I do like the amendment for increasing cities from 1 to 2. I'd like to ask you to consider if you would incorporate something similar for some of the other categories for counties, townships, and school boards, because I think different parts of the state are very different, and we can't use the city's characteristic because the rest of them aren't cities, but places in the metro versus small rural towns in outstate Minnesota have very different needs. So I would ask you to consider if we could either orally amend or come up with language that could also increase the counties, townships, and school boards to 2 and designate that one from larger, one from smaller, whatever type of language makes sense in those situations.
Senator Boldon.
Thank you, Mr. Chair. Thank you, Senator Matthews. I'm certainly open to continued conversation about that. I believe our next stop will be state and local gov, so we've got some time to work on that. I don't want the group to be too big unnecessarily, because then, it gets more difficult for work to occur, but also want it to be accurate representation to do the work that is needed. So I would propose, I'm open to further conversation about that as the bill moves forward.
Senator Matthews, follow-up.
So, Mr. Chair, being that we're the Committee of Origin trying to do the elections work, I think I would like to orally amend in some form of language 1 member to 2 members on lines 2.2, 2.3, and 2.4. They'd need some characteristics associated with it. So I'm open to, I'm happy to have this discussion here. I guess I'd like it to be considered while we're still here in the Elections Committee, and would ask that if maybe other members have comments on this committee as to whether we could try to work something out here while we've still got the bill in front of us.
Mr. Chair.
Senator Boldon.
Thank you, Mr. Chair. I just would also note, again, open to having continued conversation, but I have not heard from any of the other named entities here that they wish to do that, or that they desire that, or that would need that. And so, before we're making changes, I would want to have them involved in the conversation as well before we make those changes. And so, again, we'll have opportunity for that as we continue forward and go to state gov. So would want to include them in the conversation, and happy to continue that conversation with you as well as we move forward.
Senator Boldon, if you had that conversation and you were ready to do it, would you object, or would you tend to favor that amending the number of groups that are included in this?
At this point in time, I would not support changing the remaining numbers for the reasons I just said. We have not had those conversations. Those groups have not requested that. And so, in thinking, cities is one thing for a different size, but, for instance, the Association of Townships, I don't know that they are saying that they need 2 members on this board or on this work group. So I would want to have those conversations with them to get their input, having not heard from them about this.
Thank you. Senator Matthews, are you, did you make a motion for an amendment?
I've not yet at this time, Mr. Chair.
Would you like to? Would you like to make a motion, Senator Matthews?
Does council have a
Council
oral
have-
amendment suggestion?
I believe council has a suggestion.
Mr. Chair and Senator Matthews, I've got to start, but you need to fill in the blanks. The amendment would be on page 2, lines 2, 3, and 4, delete 1 member and insert 2 members on each of those lines. And then on page 2, line 9, after the letter B, insert the sentence, "In making appointments pursuant to clauses 4 to 6, appointing authorities must appoint members," and that's where we need to fill in the blank. You could suggest something like, must appoint 1 member outside of the metropolitan area, or something to that effect. If you're looking for that kind of geographical representation, or you could fill in the blank to do whatever you'd like to accomplish.
Mr. Chair and
Senator Matthews.
Ms. Stengel, I think that suggestion would work, so I would make that oral amendment as council read off.
Senator Matthews proposes an oral amendment as the council has read off to include,
I can read it again.
oh, okay, council will read it.
Thank you, Mr. Chair. The amendment would be on page 2, lines 2, 3, and 4, delete 1 member and insert 2 members. So that would apply to the Association of Counties, Townships, and the School Board Association. And then on page 2, line 9, after the paragraph B, insert a sentence that says, "In making appointments pursuant to clauses 4 and 6, the appointing authorities must appoint 1 member who resides outside the metropolitan area as defined in 473.121 subdivision 2. And that statutory reference is the description of the Metropolitan Council area. It's a 7-county metro area in essence.
Mr. Chair, I'd like to request a roll call.
Senator Weston. Request a roll call. Roll call.
Mr. Chair?
Senator
Mr. Chair,
Limmer.
before we vote on it, I had a question for Senator Boldon.
Senator Limmer.
Thank you, Mr. Chair. Senator Boldon, you mentioned that you would have preferred to have consultation with some outside groups. I'm assuming they're sponsors of your bill. Could you tell me who these outside groups are?
Senator Boldon.
Thank you, Mr. Chair. Thank you, Senator Limmer. What I don't know that I referenced outside groups. What I'm saying is I would want to speak with the League of Minnesota Cities, the Association of Minnesota Counties, the Minnesota Association of Townships, and the Minnesota School Board Association as it pertains, we're proposing to change their representation because I haven't heard from them that they feel that they need more than 1 member of representation on this group. So would want to have some conversation with them about that to see if they, feel 1 person could meet the need and bring that voice and perspective or not.
Mr. Chair,
Senator Limmer.
I can certainly understand and sympathize with Senator Boldon on that. Are there any representatives from those organizations in the audience that could give us some guidance at this time? If this is such an important issue for them, I would assume they would be following it and have their representatives in the audience, and I don't seem to see any. Usually, they're following important pieces of legislation, and they would want to be a participant in the discussion in a committee. I'm assuming that maybe that's not as important to them as we think. But just to make that comment, Mr. Chair, lobbyists and representatives of associations should be in the room when issues are important for them to consider and participate. And if they are a sponsor of an idea, they should be here and earn their keep. Thank you, Mr. Chairman.
Thank you, Senator Limmer. Do we have anyone in the audience who would like to speak on? No? We have a roll call vote requested. The clerk will take the roll.
Senator Carlson?
No.
Senator Coran?
Yes.
Senator Westland?
No.
Senator Barr?
Pass.
Senator Boldon?
No.
Senator Swedzinski? Senator Limmer?
Yes.
Senator Lucero?
Yes.
Senator Marty?
No.
Senator Matthews?
Yes.
And Senator Port?
No.
And Senator Barr?
Aye.
On the Matthews motion, there being 5 ayes and 6 nays, it does not prevail. Senator Boldon, any further comments?
I appreciate the discussion. I'm happy to have further discussions about the membership piece of it. But ultimately, hope this can move forward. I think it is a worthy topic for a group to discuss and look into and bring recommendations back to us to be sure that we are, modernizing our systems and ensuring that candidates and treasurers have adequate resources, and that we are if we have the ability to do so, if it is the right thing to take some of this extra work off that of city clerks and those, small town workers, that it could be, potentially centralized and create some efficiencies. So, thank you.
Thank you, Senator Boldon. Senator Boldon moves that Senate File 828, as amended, be recommended to pass and referred to the State and Local Government Committee. All those in favor say aye.
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 All those opposed say nay. The motion carries, and Senate File 828 is referred to State and Local Government Committee. Our next bill is Senator Marty, and this is a continuation of discussion of a resolution to Congress to overturn Citizens United. So this is a resolution. Senator Marty.
Thank you, Mr. Chair, members of the committee. As you recall, we had testimony on this the other day and didn't have time for the discussion of it, and I welcome the discussion. But again, we'll go back to the fact that I think that our campaign finance system is corrupting our democracy, and that that the core values of the First Amendment of allowing, as the Supreme Court said 40, 50 years ago, to secure the widest possible dissemination of information from diverse and antagonistic sources and assure the unfettered interchange of ideas for bringing about political and social changes desired by the people. I think the Supreme Court was right about the purpose of the First Amendment. They goofed in saying that more money is going to make the difference and enhance the First Amendment. And obviously, the amount of money one spends may increase their ability to have a message heard. But if you have no money, you may yell out your perspective. If you have more money, you might have a bullhorn. If you have more money, you might publish a newsletter, a newspaper. If you have a lot of money, you might buy a television network. And obviously, your ability to get your message out increases that way, but what the court missed was the fact that when you have unlimited sources of money going into from certain entities, you're shutting out other voices. Candidates who decide who runs for office and everything else, they decide not to run because they don't have the access to the big money others have. And so this is a proposal to this is a resolution to the U.S. Congress urging them to adopt a constitutional amendment that would make this change, and I urge your support and happy to have Senator Barr, whoever's discussion.
Senator Marty is happy to have you, Senator Barr, ask the first question.
Thank you, Mr. Chair, and Senator Marty. You and I have discussed this, not quite ad nauseum, but you and I have found a lot of mutual ground in this topic. Citizens United kind of put an exclamation point on what the real problem was with recognizing outside groups that it could be a union, it could be a corporation, it could be a media mogul, it could be something else that funds a lot of money into our political system. One of the things that I think that a different approach, I guess, to this would be there are two ways to amend the Constitution. You're asking Congress to basically change this so that you have to be a natural citizen to do any campaign contributions, which I do not disagree with. I still think that leaves it a little too open in my mind. I personally think if you can't vote for somebody, you shouldn't give them any money. And that's where the restriction should be. I don't think that people from New York should be funding state and local elections. I don't think they should be funding our governor's races. And I don't think people from the West Coast should be funding this, as we shouldn't be funding theirs. But I guess I'm not opposed to the program, what you want to do here. My opposition is your approach, I guess. And I don't think you're going to get Congress to give up $1 billion bone by asking them nicely. I think we as state legislators are going to have to gather in convention and craft our own amendment around campaign finance, and then decide send it back to the states for the amendment process to be finalized. But Congress is not willingly going to give up that kind of power control. Committee structures in Washington, I have heard from way too many of people who have either served in or currently serve in Congress that, at least on my side of the aisle, if you want a good committee, it's how much you can pony up at altar call. And A committees, B committees, and C committees, depending on how much you pony up in campaign money to your coffers, to the Republican caucus, determines whether you get an A committee or a C committee. And just to kind of give an idea, the only C committee that I'm aware of in D.C. is the Veterans Committee, because you can't raise money off of veterans, as opposed to building a new road or an infrastructure piece or a commerce piece. There are many committees in D.C. where you can raise a ton of money by handing out favors. And so while I agree with your intent here, Congress is not going to give up that kind of authority. I mean, they spend half their time raising money to go back and do it again so they can raise some more money, and maybe they'll do a little legislating while they're there. But usually they wait till the 11th hour and 45 minutes before they decide to get into the smoke-filled room and try and shove something down everybody else's throat, as opposed to actually spending time in D.C., in committee, debating bills and actually putting them on the floor for real votes. You get this continuing resolution, and don't quote me on this, but you might be able to shed some light later. But I believe the last time D.C. actually passed a real budget was it Bush or Obama? It's been 15, could have been Reagan. I mean, they've been doing continuing resolutions for as long as I can remember, and I can't remember the last real budget that was passed. So you spend all your time raising money to go back and then pile everything into a 2,000 or 1,500 or 2,500 page bill that nobody has time to read and pass. So while I agree with what you want to do, they're not going to willingly give this up. So hopefully we can sit down and talk some more offline about the approach. But yes, thanks for giving me the opportunity to at least have a 5-minute bloviation on how terrible Congress is. Thank you.
Mr. Chairman.
Senator Barr, I loved it. So thank you.
My congressman might not.
Senator,
Mr. Chair, I agree with probably everything Senator Barr said about that. I would point out that this doesn't just say that artificial entities can't give money. It would require states and legislatures and the U.S. Congress to adopt legislation that limits, regulates, or prohibits contributions and expenditures, including a candidate's own ones, to ensure that all people have access to the political process and no person, because of their money, gets substantially more. So it would do all those other things you're saying as well, like stopping people from giving money in other states. I don't disagree with you at all about the vision. I would also say that when I first started working on this issue a little over a decade ago, Minnesota Congressman Richard Nolan introduced a similar thing using the same language as this at the federal level. And he was a DFL member of Congress, and he had a Republican colleague from Florida who were doing one. They were trying to prohibit members of Congress from doing fundraising on their own. And he said when he had the distinction of being the member of Congress who had the longest sabbatical from Congress. He served in Congress in the 1970s, I believe, and he had 32-year gap before he came back to Congress. He chose not to run again in, I think, 1980 and came back 32 years later. He said it was just phenomenal difference in those 32 years. He left there, he said they worked 4 days a week because members had to go home on Friday. Nowadays, he said they meet a few times, much less often, and that members, especially those in competitive districts, were expected to spend, I think he said 30 or 40 hours on the phone raising money. And so he and so it was a bipartisan effort to do it. And I don't disagree how hard it is to get the change. I think it's urgent to do, and I would not let state legislatures off the hook either, because I'm afraid, and I think people will see the same thing in state legislatures, maybe to a lesser extent. I hope definitely so. But Hawaii was bringing in, I don't think I mentioned it the other day, but Hawaii 20 years ago had a scandal, pay-for-play scandal, where developers were funding their legislature and so on. And they passed a thing saying if you had a contract with the, if you were trying to get a contract with any level of government, you could not give campaign contributions in that level. And they passed it, but it had a loophole. And in other words, the corporation that was getting the money could not lobby it, but their executives and employees could give campaign contributions. And it made a big scandal. New York Times reported on about a year ago about all the money going through and how it's been the same industries that were buying access still did. And to me, I think it's just something we make assumptions here. How we fund campaigns is not a healthy one. And if this passes, we'd be the first state to pass a resolution like this. Does that mean Congress will act? I'm not holding my breath waiting, nor are you. I think it's start out by trying to make the statement and making sure people hear the statement. Public overwhelmingly supports this. I gave some poll numbers the other day, and the public overwhelmingly believes that money is corrupting our political process. And to me, I personally believe that should be small contributions only. I always thought the $100 limit was a good one because a lot of people can afford that. We have a good system for encouraging those small contributions, and public financing. Because I don't think campaigns should be anywhere near as expensive as they are, but they are expensive. And I would make the argument that if somebody's going to own our politicians, it should be the people who own them, not the powerful interests. So that's the point of this. I'd urge your support for this. I would not argue that this passes and all of a sudden U.S. Congress is going to say, hey, look what they're saying in Minnesota, we should do something. But I think it's a statement that's worth making and worth our passing.
Senator Lucero.
Thank you, Mr. Chair, and thank you, Senator Marty. I Just wanted to express, I appreciate the topic you bring up in this bill, and I share many of the same sentiments that Senator Barr expressed in that, and that you hold, and that you've, in the previous bill hearing, had articulated. I'm not sure I share all of the approach. There's going to be pluses and minuses to every proposal that's put out there, whether it's public financing, whether it's limiting it to contributions of $100, et cetera. But the thing that really, really frustrates me is the voice of the small guy just gets snuffed out. And you have so much corruption and so much influence as a result of the money that's flown around that we've become we see the system that is before us today, and it's not healthy. And I think very few agree that our system as it is right now, whether it be national or state, is healthy. And so I just wanted to let you know that I definitely appreciate this. It's a topic that it's still a work in progress, but it needs to have reform. It needs to have reform. So again, just letting you know that I'm an ally as these conversations continue. Thank you.
Thank you, Senator Lucero. Senator Sluzinski.
Thank you, Mr. Chair. My colleague to my right on his Shakespearean soliloquy on, no, that'd be you, Senator Barr. I respect and admire, but I think I have to disagree. I have a little more faith in the process, and I think if in order to amend the Constitution, if it takes 2/3 of the House and 2/3 of the Senate, given some of the arguments you said of how things have changed and how much they spend hours every week trying to raise money, I can't help but think maybe they'd see the light. And if public opinion is such that they're opposed to Citizens United, maybe this could be the groundswell of a revolutionary change, baby step in order to, maybe we could have a constitutional convention or a series of amendments. Like this could be another Reconstruction or progressive era where all of a sudden the 28th, 29th, 30th, 31st Amendments all get passed in a matter of years because of what Senator Marty started here in Minnesota. And I just think Senator Marty, thank you. I think Citizens United's the second worst Supreme Court decision of the 21st century. Sorry. Second worst Supreme Court decision of the 21st Amendment, or the 21st century. And I never in a million years would I think James Madison and the framers who wrote the Bill of Rights would think that corporations and unions are people under the Constitution, nor that money constitutes speech under the Constitution. So I just thank all the members of this committee that want campaign finance reform, and this might just be the first baby step, so to speak, in revolutionizing how we elect our elected officials. So thank you, Mr. Chair, and thank you, Senator Marty.
Have Senator Limmer.
Thank you, Mr. Chair. Senator Marty, I had to step out, but question, are labor unions included in the restriction that this proposal represents?
Senator Marty.
Mr. Chair, Senator Limmer, yes, this is any entity, including any organization or association of one or more persons established or allowed by the laws of any state, et cetera, have no rights under the Constitution separate from the rights of its members and is subject to, in other words, entities, non-human, but human-created entities of any type do not have constitutional protections outside of the rights their members have. You as a individual have a right to freely associate with others, and you can form any kind of entity you want, a nonprofit, a corporation, a labor union, whatever. You can form one, and you have your constitutional rights, that free association and so on, but like corporations were created by statute. They did not exist prior to the federal government and states giving them the power, and this would still allow them to continue to operate, and they would be, because they have responsibilities and they have rights. And they should have those, but they should be ones that are granted to them by the laws and as the people wish the laws to be. And so, yes, they would be covered by this. They would not be given those extra rights like their right to their, in the case of the Supreme Court, the right to free speech of political contributions and so on. They would have the rights that we as a state or something would give them.
Chair.
Senator Limmer.
Senator Marty, would it also restrict the very large donations from individuals, such as George Soros, Mr. Bloomberg, Elon Musk, or other tech giants that own, in my opinion, monopolies, worldwide international monopolies that seem to have unlimited amount of resource that are now influencing American politics as well?
Senator
Marty.
Mr. Chairman, Senator Limmer, exactly. This would, as I said, that, I mean, the way I would create, if this became part of the Constitution, it would require us as a legislature, require the Congress to regulate, limit, or prohibit contributions in a manner that would make sure that nobody has substantially more access to the political process or more ability to influence in any way election of any candidate or ballot measure. In other words, those billionaires, they have, if one person can give $270-some million, that's 2.5 million times what a $100 contributor would give. That's substantially more clout because money does talk. And I think donors, I think Keating 5 scandal from 40 years ago, the guy, before he was headed off to prison for his large contributions to a number of U.S. senators who got favorable treatment, and when his savings and loan was going down, and that savings and loan crisis cost taxpayers billions more to bail out because of the delay. And he was on his way to prison. He said, "Did your campaign contributions make a difference?" He said, "I certainly hope so." And I think that the people who are making those kind of contributions are doing it because they think it makes a difference. And so, yes, this would stop all of that. My presumption would be that a legislature like ours would have no option, in order to comply with the constitutional amendment, would have no option but to say it's going to be small individual contributions, as Senator Barr points out, probably from within that jurisdiction that the person's running in, and that nobody else, outside entities, whether PACs or super PACs or lobbyists or anybody, could put money into it and be public finance money for some of it, because I think a lot of people we don't want to contribute to campaigns, but I'd rather the public own the politicians rather than the interest groups. So yes, it would stop the billionaire contributions, and I'd argue unfair access to our process.
Mr. Chair, Senator Marty,
Limmer.
could you point to the line and page where it states that individuals would be limited in participating in the financial way?
Sure, Mr. Chair, Senator Limmer, on page 2, the paragraph beginning on line 13, federal, state, and local government shall regulate, limit, or prohibit contributions and expenditures, including a candidate's own contributions and expenditures, ensure that all citizens, regardless of economic status, have access to the political process, and here's the point, and no person gains as a result of their money substantially more access or ability to influence in any way the election of a candidate for this. So, in other words, if you accept, which I think this is making as a premise, that money does make a difference, you cannot, if you're giving $50,000, forget $2 million or $100 million. If you give $50,000 or whatever, and most people can't do that, and it's making a difference in political races and so on, we would have to say you can't do that in order to comply with the Constitution. This is meant to take the big money out of politics, period.
Senator Lewin. Senator Coran.
Thank you, Mr. Chair. And Senator Marty, I think we all share similar values, but what I missed is, unfortunately, we had the same, when we kicked it off, you had all the testifiers, and I love it when they come in, everybody comes in. The nonprofit, nonpartisan, filled with partisans, always supporting the goal to get rid of dark money, many of them funded by dark money, out-of-state money. And so we're very selective in our outrage. I think we agree on the outside. How do we get there? I think Senator Barr did a great job at describing it. But what you focused on in the entire process here was, I think, the delineation between good billionaires and bad billionaires in your opening statements the other day. And so you highlight, right, an Elon Musk or whatever. You left out the Soros or the Zuckerbergs who you guys benefited from. And even your party voted against keeping that money out of Minnesota. So the selective outrage is always frustrating when we do believe we would like to keep them out. And so you've got I think we'll probably do our ranked choice voting dance. That's funded by outside money under the guise of some local initiative. Still don't want to vote that out, right? Don't want to stop that dark money coming in. So I think what we should do is focus on and have this same zest and zeal. Try to push what you're doing. I think it would be great if Congress would act on those. You know they won't. And let's do what we can do here at home. You know, we've got reporting. How do we want to make sure our reporting of our own campaign finance? We're bringing municipalities in now. But let's start right at home and let's support those things to ensure they don't infiltrate our politics. That we can do right now. And every single step of the way, it's been blocked. Not by us, but your party. And so let's keep doing that, and let's move forward. I think you could. Senator Limmer brought up the public union. You know, are they excluded or protected? Let's denounce them. That you can do today. We can make those changes today. Let's do what we can do here in Minnesota and continue the narrative of what should happen nationally. It would be wonderful. But every step of the way, it's been blocked here locally to be able to stop those things from infiltrating and provide that undue influence. And the other part, I think the one we've focused on is kind of the cash contribution, right, or the monetary contribution. The other piece I do think that needs to be added is what then is deemed as an in-kind contribution for pure political partisan purposes. That in itself is likely exponentially larger than kind of the big dollar donation, right, that we talk about, those hard cash dollar donations. When you look at big tech, what they've done to interfere in elections or to influence elections, large corporations, not just the contribution, but the actual in-kind contributions and the influence put in. That's not a measured activity today, but equally or equally or more influential in the effects on our elections. It would be good. I think we would agree. Businesses should get out of politics, party politics. And I don't understand why they would in many cases. We just had a bill talking about a person that got terminated because of it. We've had our elected, I'm sure you have had on your side, people that have lost 40% of their business because they got elected and served because of partisan politics. So I think there's ways I think we have to expand it, but I'd like to certainly have an honest conversation about, let's start here, let's do the things we can do here, but everywhere we've turned around, it's been blocked. But also, can we work together to figure out, Senator Marty, how do we track the real contribution, both that in cash and monetary and in kind, because that in kind is exponentially larger than the cash, and it's not reported. So, thank you, Mr. Chair.
Thank you, Senator Grant.
Mr. Chairman,
Senator Marty.
I wanted to comment about this so-called selective outrage where I find some billionaire contributions acceptable and some not. some billionaire contributions acceptable and some not. I've never found billionaire contributions from anyone acceptable. That's why we're trying to do this. And when you said, oh, you had witnesses come in, they're probably funded by dark money and billionaires and so on. I had 4 groups I can name. Move to Amend Minnesota. I think 1 or 2 of them are in the room. These are guys who volunteer. They don't have any money. They don't have any lobbyists. They don't have anything. These are individuals who care. There are a lot of people like that. Not a lot have the time to come here and so on and the knowledge to do that, but they care. Clean Elections Minnesota is a fairly new group in Minnesota. I think it's clearly one that's been very vocal and very involved in trying to change things here. They have a part-time paid staff person that they can raise from their small contributions. Common Cause Minnesota, it's been a national group for years, but they have a low budget. League of Women Voters. These are not wealthy groups funded by anybody big. They take small contributions to do it. And in terms of the stuff, in terms of, hey, I passed a number of campaign finance reforms many years ago here, some of which were thrown out in court by a lot of interest groups, some of which were ones that you would call, if I named the groups, one of them was thrown out by, I believe, U.S. Supreme Court, funded by one group that I think you would say is very clearly Republican tilting, and another one that's very clearly DFL tilting. They challenged it because it was going to limit their ability to make big contributions in independent expenditures. I am not somebody who has
Senator Marty.
selective outrage. So
Be close to
I'm
the
sorry.
microphone.
I am not one with selective outrage. I just think that this is all a scandal, and the fact that anyone who's saying this is a problem, we couldn't do a lot of those things because the U.S. Supreme Court interpretation of what free speech is, and that's why we have to change this. And we cannot do a lot of those changes here because we're not allowed to. Senator Barr's suggestion, which I don't disagree with at all, namely that we should only allow people to contribute in races they can vote in. I don't have a problem with that. I think that's an appropriate thing, but we can't do that. The U.S. Constitution doesn't allow that according to the Supreme Court. That's why we need it. So in any case, I just wanted to speak out and respond to this thing that you're saying we have selective outrage. I find the whole process outrageous, and I think it should be something that, like the American people of both parties should speak out and try and change it. And even if we're not sure that federal government will change it, I think this is a first step.
Thank you, Senator Marty. I'm tending toward asking you for your final comments.
That's enough.
That's enough? Okay. We do have...
Mr. Chair, I would move this bill be recommended to pass and referred to, I believe, the Rules Committee.
Mr. Chair, I request a roll call.
Goes to where? Senator Boldon moves to have a roll call and move this bill to the Rules Committee. The clerk will take the roll.
Senator Carlson?
Yes.
Senator Coran?
No.
Senator Westland?
Yes.
Senator Barr?
Aye.
Senator Boldon?
Aye.
Senator Swedzinski?
Yep.
Senator Limmer?
No.
Senator Lucero?
No.
Senator Marty?
Aye.
Senator Matthews? And Senator Port?
Aye.
On the Boldon motion to recommend Senate File 569 to pass and referred to Committee on Rules, the vote is 7 aye and 4 nay. The motion is adopted.
Thank you,
And
Mr. Chair, members of the committee. I've got a long road ahead on this, but thank you.
Yes, Senator Marty, I think you do have a long road. I'm hoping that it is well lubricated for you to get somewhere. That being all we have on the agenda, and it is 4:45, we will not have to meet on Friday, so the committee is adjourned.